All right, let's talk about chapters 9, 10, and 11. Before I get there, let me briefly fill you in beyond the email that I sent out recently about why we're kind of calling an audible, if you will. Normally, when I do this course in person and when I've done it in the past, we've kind of jammed in the material, much like we've done this semester, and then spent the final several weeks of the semester negotiating. And I realized about 2 weeks ago that we were way ahead of schedule. And one of the reasons I haven't been really pushing things is because we were so far ahead, I wasn't sure what to do, and I really had to spend some time kind of rethinking where we needed to be. So I apologize for that. Um, Unfortunately, that was one of the things that I wasn't sure how it was going to work out, rolling out a online negotiations course. So what we're going to do is just negotiate throughout the month of November, and so you'll get some more back and forth amongst you, so that we can actually have that going on instead of just simply going through the sort of academic process and the content. So anyway, I'll send out some more details for that. We're going to wrap up here shortly, and so in fact, I will set out a schedule and partners for negotiating for the next, basically for the rest of the month, and I want everyone to contact me so we can set up that final live video negotiation. What we'll need to do is set up sort of appointments uh, for you all to negotiate and for me to be part of that. I will be silent, but I will be listening in and watching. All right, let's get to chapters 9, 10, and 11. We won't do chapter 12, which is related to arbitration and mediation. Please read that chapter, but I think it takes care of it, and I don't think I really need to quiz you on it. You just need to read it and take a look at it. All the principles that you would use pretty much are going to apply in arbitration and mediations, and I didn't see any need to kind of really worry too much about that. You can figure that out. Chapter 9 is multi-party negotiation, and one of the things that is really a big issue in multi-party negotiation that doesn't exist when you have just a one-on-one is coalition building. And the idea behind coalition building is just like it sounds. Different groups sort of maneuver around and sort of become partners, if you will, from time to time. And you can see people going back and forth sometimes even from one coalition to the other until they find the spot they like. Now, what does this mean? Well, when you have at least, if you have three parties, two might gang up on the other is essentially what that means. And why might they do that? Could be any number of reasons. It could be that the two who gang up on the third, for instance, if there's three parties negotiating, the two feel like they have the most in common, or they simply recognize that it just makes sense for them, even though they hate each other's guts, it makes sense for them to get together and try to get something out of the third party. So um, sometimes coalitions won't form. They might not form because it just doesn't benefit anyone for it to form. They might not form because sometimes people behave irrationally. Even people that you would otherwise expect to behave rationally still may not. You might expect that if you have three businesses who are trying to work something out, that you'd think, well, they're all going to behave rationally. They're all business people. Not always, and don't count on it. You may sometimes find yourself in a position of having to be the voice of reason in order to get everybody, get everybody going and get everybody together. Sometimes the stronger party, who's got a real ability to undermine the coalitions, may be able to get the other two weaker parties to sort of fight each other and then sort of step back and just let them kind of pick on each other, and then no coalition forms. You would assume that coalitions would often form between the weaker parties against the stronger, but that's typically probably not what happens. Normally what happens is one of the weaker parties figures out, I better latch onto the big guy, and the somebody else who's weaker ends up getting beat up oftentimes. So These are things that will go on as you are dealing with multi-party negotiations. When do these kind of negotiations happen? Typically, you would see these in situations where you have multiple countries trying to negotiate a treaty, for instance. If you get into that kind of international relations sort of legal practice, you might find yourself involved in those kind of negotiations. Sometimes you might see mass torts where you've got multiple parties involved. Maybe you have 3 or 4 different parties who are the potential tortfeasors. That can even happen if you have personal injury matters where you've got several potential tortfeasors who may have caused an injury, and you find multi-party negotiation going on. So those are all examples of when that might occur. Could be a business deal in which the government is a negotiating party, and then 2 or 3 different business people or businesses negotiating contracts or negotiating purchases of land, or whatever, the delivery of services to the government perhaps. You could see that occurring. A large construction project often involves multi-party negotiation because you have a lot of people that are involved in that. The general contractor, subcontractors, the government inevitably. And so you could find yourself with multiple invested parties. So what do you do? If there's a lot of parties, you're going to need some ground rules. You can't just do it without ground rules if you have 20 people who are involved in the negotiation process. You're going to have to decide that, and that alone will result in negotiations about how are we going to do this. What else? If the parties are really numerous, and I don't know what the magic number is here, 10, 15, 20, I don't know, but at some point, if there are enough people, you're really going to have to actually write down the rules for negotiating, I think. And so that could become something that you'd actually have to take care of before you even start negotiating the substance. You'd have to actually come up with some procedure. And so that's a possibility that you'll have to keep in mind if you have a sufficiently large group of people. Again, that's probably usually what you're going to see that when you have a very large business deal, I mean an enormously large business deal, or a multi-nation type situation. So that's not going to come up often. The single negotiation text is a potential means of solving the problem of multi-party negotiation. That is, if you know you're going to end up with a document that's going to be the result of the negotiation, you just simply write a document, and then folks add and subtract and circulate the document in a way designed to get everybody to take a good look at it. Even if you've only got 2 people, that often can be a very successful tactic. Let's say you're going to do a lease or a contract of some sort. I mean, even in divorce negotiations, if you've got a property settlement agreement between a husband and wife, actually putting the document together, oftentimes both sides see that they kind of agree on 80% of stuff, or maybe 90, or maybe even 95, and so there's only a few things they really need to iron out. That's very helpful oftentimes because it allows the parties to recognize we have enormous area of agreement, and so we can concentrate on where we disagree and get it fixed, and knowing that we have a large area of agreement. That's always very helpful in sort of having that, because the mindset becomes, hey, we're generally in agreement, we're just trying to knock out some details. People have that attitude, they're much more likely to get things resolved than if not. Sometimes you may, if you have a number of parties and you're having difficulty either getting going, or you're having just difficulty getting the matter resolved, you may want to get a mediator involved who can kind of get everybody together and sort of bring people together and say, hey, let's see what we can do here. That's always a possibility. That could be expensive. It's not something you would do in a small situation, but if you have a significant enough again, business deal or other kind of negotiation, you might want to bring a mediator in to kind of pull everyone together. That kind of takes care of multi-party negotiation, or at least what I'm going to say about it. Read the chapter as well, and we'll go from there. Negotiation counseling is chapter 10, and just a few comments on that as well, really. Uh, Remember the ethical rules. If you're an attorney, the ethical rules play a huge part in negotiation counseling because A, you got to let your client know they have control. Even if you have a very unsophisticated client who needs to be tempered, you still need to let them know that the final decision is theirs. You may want to try to steer them very carefully. Oftentimes, look, I've been involved in the personal injury law for many years on both sides, and so I'm very aware of what happens when you have plaintiffs who have unrealistic expectations that their case is worth $1 million because the McDonald's lady got $4 million for dropping hot coffee on herself. Um, and people just think that, oh, well, I'm going to get $1 million. No, you probably aren't. For your run-of-the-mill soft tissue automobile accident case, you're not going to get $1 million. And so you have to temper expectations sometimes, and you have to be honest with people and be very clear with them that, look, this is how this is going to go down. So in counseling, one of the things that you're going to need to do is you're going to need to be honest and direct with your clients. Obviously you don't want to run roughshod over them. You do need to be careful, though, in pushing them too far in any given direction. They have got to make their own decisions, even for your less sophisticated clients. Your more sophisticated business clients, they'll understand they're in charge, and they'll understand you work for them, and they will understand that they are going to make the final decision. They know that. You don't have to tell them. They already get that. They don't need you to tell them that. What they want you to explain to them are the legal intricacies, and they may want some help with the negotiation, but they're not going to care about learning that they have control. They know. Less sophisticated clients don't know that. Psychologically vulnerable clients, and particularly I'm thinking here of divorce cases, especially, they really need you to guide them through the process very carefully. And so counseling is going to be a big part of what you do. Oftentimes, you're as much of a psychological counselor as you are a legal counselor. And so you've got to keep that in mind. Patience, compassion are very helpful qualities to have, especially if you're going to get into an area of law in which people are very much routinely subject to psychological problems and issues. And again, I'm thinking particularly in the domestic relations field. Criminal cases, that can get really kind of funky because if you get into criminal defense, for instance, criminal defendants are all over the map. Some of them are actually fairly sophisticated users of the legal system, not so much because they've been in and out, and they actually kind of have an idea of what's going on, some of them. Some of them are just not very intelligent, and that's why they seem to move towards criminal activity, because they just don't think it through very carefully. And as a result, they need a lot of guidance. And then some of them are just emotionally troubled, and you're going to have to spend a lot of time counseling in a really a true psychological counseling sense. So you're going to have to wear multiple hats oftentimes as an attorney in taking care of your clients. When you are getting prepared to get into a negotiation, you're going to need to spend some time with the client in advance and letting them know, particularly with relation to the tactics you intend to use, what you're doing and why. It's very important for the client to know that sometimes it may look like you're throwing them under the bus, as we say these days, and you really aren't. Or you have a reason why you might be using a particular tactic that they may think is sort of not as aggressive as it should be, for instance. Maybe you're trying to use sort of be in a cooperative vein at the beginning of a negotiation, which we've discussed can be risky, but maybe you explain to them, in this instance, there's a reason I'm doing it, and here's the reason why, and you need to know why. Communication with your client is going to be the biggest key, and frankly, one of the biggest sources of bar complaints against attorneys is lack of communication with clients. So just stay in communication with them, make it clear, let them know what you're doing. Most of the time, most clients, even sophisticated business clients, if you tell them what you're doing and why, most of the time they're happy for you to do what you do. okay? And so it's good to meet with them in advance, make sure that you've explained the process, whatever it might be, whether it's a mediation, an arbitration, whether it's just a face-to-face negotiation, whether you're just negotiating via email, which again, is going to happen a lot with you. Gosh, these days I suppose you all will be negotiating via text message, Instagram, Snapchat, whatever all these other things are. Despite my appearance, I'm quite a bit older than most of you probably are, and those are things that I know about only because I have a teenager at home, but otherwise I don't use. I mean, I do text message, but I wouldn't do it to negotiate anything, but you may, and very likely will. And so you need to keep kind of keep those things clear, how you're going to use them, what you're going to do with them. Let the client know in advance what you're doing and how you're doing it. One of the things you should do in getting the client prepared is to make sure you let them know what the alternatives are, as many as possible, and in some detail. Here's your potential alternative. If there are 3 or 4, great. If there's only a couple, that's fine too. Just let them know, look, I only see 2 possibilities here. Either you take the plea bargain or you go to jail, because I don't think I can keep you out of jail unless you take this deal. The client may say no. Look, I had a case many years ago where I had a young man who was accused of, I don't say molesting a child, it's not the right term. He was accused of touching a child inappropriately and also exposing himself to a child inappropriately. He insisted that he was innocent. He said, look, I didn't do it. I mean, he just insisted, I did not do this. And he said, he was absolutely like, look, I didn't do it. I don't want to admit to doing anything. I had talked to the Commonwealth attorney in Virginia, in a city in Virginia where I was litigating, and had said to them, well, what kind of a deal would you be willing to give my client? And the Commonwealth attorney had told me, if he'll plead guilty to assault, we'll call it a day. And she had some problems with her case. So I told my client, I said, look, you can plead guilty to assault and battery. I said, you won't get any jail time. It's a misdemeanor, and we'll just put it to bed, and you get some probation, and the whole thing goes away. And he said no. Now, he was charged with a felony, and he insisted that we go forward. And I had to explain to him, listen, if you get convicted of a felony, you might go to prison. And I can't guarantee you that I will prevail. I mean, I'll do everything I can to defend you, but you could lose. And then if you lose and you get a felony conviction, you're going to be a registered child, sex offender here. And do you really want to take that chance when you can just plead to assault and battery and get it over with, and jail time? It's a misdemeanor, and it's not a sex crime, and so you don't get registered and all those things. He absolutely refused. He said, no, I'm not pleading to anything. I mean, he wasn't going to plead to illegally playing tiddlywinks. That's probably a bad reference, because most of you probably don't even know what tiddlywinks is. But anyway, you can Google it. He wouldn't plead to anything. And so we had to go to trial. Now, through the way the trial ended up going, for a variety of reasons, I won't bore you with all the details of the case, but we ended up prevailing. Now, it wasn't so much because of him, because he never testified. The case was dismissed after the Commonwealth presented its case for a variety of reasons that had to do with the evidence, the way it came out in the Commonwealth's case. But there was an instance where I had negotiated what I thought was a really nice setup for him to plead to a misdemeanor and just get it out and never have to worry about it again, and never have to explain to anyone, and no chance, no risk whatsoever of him becoming a sex offender, anything, and he would not. So you just, your client is going to control it. The client's going to be in charge. You need to let them know that's fine. You just need to let them know all the possibilities and explain to them what could happen if the negotiation fails. Can you tell your client what to do? That's always an interesting question. That's a difficult one. I think the best answer to that is you probably should not ever suggest that you are telling them what to do, other than to say, this is my best advice. You know, if they say, well, what would you do? Is it okay for you to tell them? You know, that's always debatable, because if you tell them what you would do, there is that impetus that you're the lawyer, that you know things they don't know, you have a much better grasp of the legal system, and they may say, gosh, if that's what the lawyer would do, then that's what I'll do, even though maybe that wouldn't be their best result. Look, the case I just described to you, I might have very well pled guilty to a misdemeanor assault and battery charge just out of fear, even if I believed I didn't do it, and even if I was genuinely believed that, and was genuinely like, look, I didn't do it. I did not do it. I absolutely didn't do it. I can't. I think the fear of risk in me would say, you know what? I'm not taking a chance of ever being convicted of a sex crime just on the off chance that that could happen. I'd rather plead guilty to assault and battery, which doesn't come up as a sex offender, and I won't be registered, and none of that will ever happen to me, and I never have to explain to somebody any of that nonsense. I'll take it, especially with no jail time. I might have done that. So if he had asked me, what would you do, that would put me in a really difficult bind. So it's a tough decision to make. You're going to have to feel out the circumstances. You're going to just have to be delicate about it. I think the best thing to tell people is, look, I can't tell you what to do. I can only give you my advice. Here's what I think the odds are. Here's what I think could happen. Here's where I think this is headed. Based on my experience, based on the law, based on these circumstances, these are the things that could occur, and you need to take them all into account and make the best decision you feel like you can make. I can't make the decision for you. You have got to be the one to make the decision ultimately. And really, for your own protection, you want the client to make the decision. So, I mean, even as a practical matter, as a lawyer, you really want the client to be the one to make the final decision. You don't ever want them coming back and saying, well, the lawyer told me to do X, when X turns out to be a really bad idea. Sometimes you just have to let people, kind of cook in their own soup, as it were. When should you have any kind of sessions with your client when you're negotiating? Well, before you negotiate, during a negotiation, and after the negotiation. So basically, you're always in counseling mode when you're negotiating something for your clients. I mean, is there any particular time? No. Constantly. You're always counseling. You're always advising. It's back and forth all the time. So it's basically an ongoing process throughout. Certainly at the beginning, you're going to want to lay out as many alternatives as you can. As things narrow and you start to finish, obviously the alternatives become fewer and fewer. And then ultimately, perhaps you're confronted with just a choice, a stark A or B. You either take A or you take B. Usually that's kind of where you end up in a negotiation. Obviously, at some point, you either settle or you don't. You either take the deal or you don't. So at some point, you will have gotten to that final yes or no kind of response. And again, you will have been counseling the entire time. Last few things. Chapter 11, negotiator identity issues. We often get very concerned about stereotypes and generalizations. And especially these days when, gosh, you can't say much of anything about anyone without offending somebody, which makes taking into account identity issues get to be touchy. But nonetheless, you have to think of these things. And so I'm going to give you some general things to think about, with the caveat of understanding that, of course, any generalization doesn't apply to every single person. Stereotypes are stereotypes. They have a kernel of truth to them. They may or may not apply to people, but they certainly at least have some nugget of truth, because they're kind of a general view that have developed, that didn't just develop out of nowhere. And so these are things to think about, but to to take into account and to just use as you will as you're negotiating. And just sort of, these are general ideas that can help, but you can't let them run the show for you. What about time? You have two types of sort of cultures here: polychronic and monochronic. Polychronic, obviously poly meaning many, chronic meaning time, chronos, time. That's from the Greek. Mono is one, and again, chronos is time. Basically, polychronic cultures tend to view time sort of less, what's the word I'm looking for, directly, okay? You might have Middle Eastern cultures, Mediterranean, Mexican, where time is not as important to them. It's not this beeline from point A to point B. It's more of a meandering. And so people don't get upset if you're late for meetings. In fact, they don't maybe care at all that the thing starts when you say 10 o'clock and it starts at 11:30. That's okay. We just we're going to get it done. Whereas, let's face it, in the United States, that's just a sign of it just terrifies us if things aren't done on time and aren't done in the way we anticipate them being done. And so it doesn't work in the United States or Northern European countries. Japanese either. There's sort of this offense taken if you're late. So keep that in mind. It's not a hard and fast rule, but it is something to keep in mind as you're negotiating. And maybe some of you've had those experiences already with people from different cultures. Even the difference between North and South in the United States, it's still true that things are a little lazier in the South. I'm a Southern guy and I'm a Southern boy, and I know that Southerners generally, and again, it's not a hard and fast rule, but generally speaking, Southerners do tend to take their time a little bit more than folks from maybe the North or the Midwest or even the West Coast. West Coast, I can't say. I really have very little experience with that, so I guess I should leave that out. But there certainly is a sense that time doesn't have the same importance for Southerners as it maybe does for other parts of the country oftentimes. It's not completely true. It's not always true. But there is that sense, even today, here in 2014, there's still some semblance of truth to that. So those are things to keep in mind. Does it mean they're hard and fast rules? No, and don't take them as such and don't treat them that way. Spatial orientation, again, same thing. Different cultures have different spatial ideas. In the United States, you don't want to get right up on somebody. You don't want to touch them. That's just very offensive. In other cultures, touching people is fine. I'm the kind of guy who likes to, I touch people a lot when I'm talking to them. I'll put my hand on their shoulder. Okay. You better know, especially if you're dealing with people of other cultures, you want to kind of scope that out in advance and do your homework as best you can to make sure you don't do things that are going to offend them. And just take those into account. And of course, you're going to want to tell your client as well. I've done some research on this in the past, and I'll just throw a couple of things out at you. I'm not going to overwhelm you with this, but just some things to think about. For instance, American negotiators, what do they like? What are things that American negotiators think are good things? Well, preparation and planning, thinking under pressure, using good judgment. What about Japanese negotiators? Well, dedication to the job, perceive and exploit power. Those are things that Japanese negotiators like to do. Win respect and confidence. How about Brazilian negotiators? Very similar to American negotiators, although they very much favor verbal expressiveness is a big deal to them. So those are just, again, some generalizations. Don't apply to everybody, but may be helpful in thinking about those kind of negotiators. If you're going to do any kind of international negotiations, you're going to want to spend some time getting to know the culture of the folks with whom you are negotiating. It's going to be very important. And so to the extent you do that, you're going to want to do some homework. Again, keeping in mind that just because it's generally true doesn't mean it necessarily applies to the person with whom you're negotiating, but at least it gives you some basic ideas of things that you might expect, and if you then see them, you're not surprised or frustrated, and your client isn't surprised or frustrated. Okay, even things like looking someone in the eye, and I don't remember which cultures this applies to, but sometimes that's perceived as very offensive to look someone in the eye. In American culture, when we look someone in the eye, it means we're being honest. But other cultures, you look someone in the eye and that's disrespectful, and so you don't do it. So again, you'll have to kind of do your homework when you're dealing with that. On the American front, just American front generally, I've already mentioned about Southerners and their perception of time being perhaps sometimes not as aggressive as that of others in our country. Are there differences between men and women in negotiations? I've negotiated with men, I've negotiated with women, I've observed many students negotiating. And I would say that I'm going to give you a general rule of thumb, and again, this is a general rule of thumb, so it's not going to always apply. Women negotiating with men oftentimes tend to be more cooperative. Women negotiating with other women, not so much. And that's just my observations, both professionally and through seeing probably literally at this point hundreds of negotiations between students. And so it always is interesting to watch the ladies negotiating with other ladies and getting very aggressive with each other, whereas when they negotiate with men, not nearly as much. So again, that's my anecdotal observations, even professionally as well. It may just be the people I've seen, but it does seem to be a general thing. Do race issues matter? Not that I've observed. I mean, I haven't seen any difference in people of different races as Americans. That's going to, again, internationally, that's not what we're just talking about Americans here. I've not perceived any difference there that I would treat anybody differently because of their race. That doesn't seem to matter. The male-female thing seems to matter a bit more than other things. What about rural versus urban? Does that matter? Yes, it does. And again, I'm here to tell you, I was raised mostly in the country. I've lived in cities. I've lived in the country. And there is a big difference between going to deal with a country boy who's going to want to talk about things for a while before you start negotiating. And you're going to, there's just a, generally speaking, and again, this is a general observation, there's sort of a politeness factor that you have to talk about stuff before you actually start negotiating. Whereas with city guys and gals tend to be a little more direct, in my experience. And again, it's a rule of thumb, may not always apply, but it's sort of a general thing. So don't get frustrated if you're negotiating with someone who's out in some rural area and they seem to want to talk about, the weather or the crops or the dogs or whatever they're talking about, or fishing or hunting. Fine. If you're not comfortable talking about those things, just roll with it. Ask them some questions about it. Nothing at all will come of it if you or hurt you if they start talking about hunting and you know nothing about hunting because you've lived in the city your entire life. Well, then ask them some questions about hunting. Oh yeah, what guns do you use? How long does it take? Do you really sit in that deer stand for hours on end with not even seeing a deer, and you enjoy that? Well, why do you like doing that? Just humor them basically, and don't be afraid to do that. All right, well, that gets us through chapters 9, 10, and 11. I told you that, that's about the length of time I normally spend on one or two chapters. Chapter 12, go ahead and read it, as I said, and there won't be I won't quiz you at all on chapter 12. I'll post a quiz here shortly. We'll use Unit 6, will be the unit that we use to go through chapters 9, 10, and 11, so I will open that up and post a quiz there shortly. I'd like you to wrap up Chapter 5 or Unit 5's quiz and Unit 6 quiz by Halloween, or even November 1st or 2nd will be fine. And then we will commence negotiating, and I will send out a schedule with people with whom to negotiate here in the next few days that'll cover everybody you're going to negotiate with for the rest of the semester. And so you'll see more about that as I send out emails in the next few days.